Southwest Airlines lawsuit could be a new playbook for DEI litigation moving forward. For years, Southwest Airlines has run a special program to assist Hispanic college students living far from home. It's called Lanzate, or Take Off, and it gave a select number of students free flights to visit their families as they pursued their studies, or the chance for their parents to visit them in turn. What the fuck? I want free flights! Isabella, one of this year's recipients whose last name was withheld in publicity materials, said in a statement that the program would allow her to see family sooner than expected, adding, "I'm so excited to see my little cousins and how much they've grown. My grandparents, hopefully I can convince my grandma to make mole, and of course my mom, in person this time." Why do they get fucking free flights? Isabella's class of Lazante winners will be the last, thank God. In May, the program was targeted by conservative activist Edward Blum and his American Alliance for Equal Rights, which claims that Southwest discriminated against two of its non-Hispanic members, therefore violating two civil rights laws. Yeah, if you're gonna give free flights, give it to everyone! In an attempt to have the lawsuit dismissed, Southwest terminated the program and offered Blum's group 1 cent. The amount of damages the group claimed. But a federal judge has decided that those actions won't be enough. The case against Southwest Airlines will go forward, said U.S. District Judge Sidney Fitzwater in an opinion last week. This has the potential to create obstacles for other companies facing anti-DEI lawsuits that try to have cases thrown out by canceling or changing the terms of their DEI programs. And see, this is something that we can call a win. As long as these people who notice the changing of the terms for the DEI programs continue to bring the lawsuits after the language is changed, this is fucking winning, man. This is how you recognize a win. Attorneys say it could mean a strategy shift when it comes to the ongoing legal battle over DEI. It reflects a new playbook by one of the key players fighting DEI programs in the courts. Lauren Hertz, an attorney at Jenner & Block and co-chair of its DEI Protection Task Force, told Fortune in an email. DEI Protection Task Force, man. What the fuck? Southwest Airlines declined to comment. The Hispanic Association of Colleges and Universities, which had also been a partner in the programs, did not immediately respond to Fortune. Blum told Fortune in a statement that the alliance is grateful that our case against Southwest Airlines racially discriminatory programs will proceed. Sorry, my brain stopped. The group issued a separate statement to the press in response to the judge's ruling, saying that the decision is a powerful tool to prevent case-mooting tactics from discriminators nationwide. And I agree. That judge was not playing with these fucking word games, man. Based judge. The Southwest lawsuit is the latest in a wave of similar legal challenges brought against U.S. companies by the AAER. Students for Fair Admissions, a separate conservative group created by Blum, was behind the push that saw the U.S. Supreme Court overturn affirmative action in college admissions in 2023. In a high-profile example of his activism in the private sector, Blum's AAER challenged a venture capital firm in Atlanta, the Fearless Fund, which we've read about on stream. That was great. The Fearless Fund people were literally coping and seething while this was happening, for running an annual program that aimed to support startups run by black women. In that case, the two parties came to an agreement that saw the Fearless Fund shutting down the program in question, and the case was dismissed. Now, companies that fear legal challenges from Blum or another activist over DEI efforts may not have the same option to have a case dropped by dismantling the programs at the heart of the dispute. After the court's decision, it's less clear if that off-ramp is available to companies, and it's more important that they be proactive. The AAER relied on legal technicalities to make the case, representing a departure. She also said when AAER started bringing lawsuits, it was focused on making changes to targeted DEI programs at specific organizations. And when those organizations agreed to modify their programs, AAER was generally satisfied to claim victory and move on. See? All right, this is the woman. This is the woman who is a fucking... Where is it? What's her fucking title again? What was her fucking title? Where is it? There's like some DEI protection bullshit. God, I can't find it. No, I don't want to bookmark it. Cancel. I want to control find DEI protection. Lauren Hartz, attorney at Jenner & Block, co-chair of its DEI Protection Task Force. DEI Protection Task Force. When those organizations agreed to modify their programs, AAER was generally satisfied to claim victory and move on. And that's the problem. Don't assume that them modifying the language is a victory. So hopefully, like this base judge, AAER does not take a satisfactory, oh, we'll change a little bit of things here and there. Hopefully they keep gunning at it. This lawsuit signals a new and more aggressive approach. AAER isn't just working to target and change particular programs, it wants to change the law itself. The crux of AAER's complaint against Southwest Airlines filed in a federal court in Dallas is that a program harmed 2 of its members by excluding non-Hispanic students, violating the Civil Rights Act of 1866. Sorry, I keep having like hiccup feelings. Which bars any racial discrimination in contracts. And Title IX of the 1964 Civil Rights Act, which prohibits racial and other forms of discrimination in programs or businesses that receive federal funding. Lanzate winners signed contracts with the airline to participate, and Southwest accepts federal funds, leaving it open to such claims. The organization states that on a FAQ website about Lanzate, the airline's answer to the question, is this program only for Hispanic students, was yes. To be eligible, the student must identify direct or parental ties to a specific country to determine Hispanic origin. The alliance claimed in a suit that 2 college students, one white and one Asian, identified only as A and B, wrote essays to apply for the free flight program, but could not submit their applications because they could not agree to the stated terms around eligibility. Those 2 students then joined the alliance, according to the court document. Members A and B find Southwest discrimination against them deflating, disheartening, offensive, and hurtful. Southwest website links to a current description of Lanzate that says it is open to students from all ethnicities. The company made that change after the AAER launched its suit, according to court documents. Over 20 years, some 1,500 students have benefited from the competition, which awarded honorees with 4 free flights. Again, it's open to all ethnicities, but I feel like they're just probably not going to accept the wrong ethnicities, quote unquote. Canada is similar for Indigenous people. How's that modifying the law? Just enforcing anti-discrimination? Because they want to change the law to make it so that DEI initiatives are expressly illegal, like more so than what the current laws have on the books. And it's also really nice to just notice like actual wins. Not like Robbie Starbucks fake wins, but like real ones that we can see tangible responses to.